All right, welcome back to the deep dive. We know you're here because you want to really get
And you
contracts.
want to do it without wading through tons of legal jargon.
Yeah, you want the key insights, especially when you're dealing with more than just two people in an agreement. So today, we're going to cut through the complexity and get right to the heart of who the parties to a contract actually are.
Absolutely. We're taking a deep dive today into the fundamental element of any contract,
Hmm.
the parties. We'll be using excerpts from a legal textbook, a contract law study guide, and a general explanation of contractual parties to guide our exploration.
So what's the mission for this deep dive?
Our goal is to clarify the different ways multiple parties can be involved in a contract.
Focusing on their liabilities.
Yes, what they're responsible
For their
for.
entitlements.
Exactly, what they have a right to.
And we'll also touch on agents
Those acting on someone else's behalf.
and third-party beneficiaries.
Those who benefit from a contract they didn't directly sign.
Okay, so by the end of this deep dive, you'll have a much clearer picture of even the most complex contractual situations. Sounds good.
Sound good.
All right, let's jump in. Starting with the basics. Every contract needs an agreement, right?
That's the foundation.
At least two people need to be on board.
At least two sides. Our sources highlight the concept of a concurrence of wills or intentions, meaning both parties need to be on the same page about the core terms of the contract.
Right. You can't really contract with yourself.
Generally, you can't. There's a slight exception where you could contract with yourself if you're acting in two entirely different legal capacities.
Oh, interesting. Like what?
Imagine someone acting as an individual in one role and as a trustee of an estate in another.
Ah, I see. So they're separate legal entities?
Precisely. But the core idea holds true. A contract needs at least two distinct entities.
Makes sense. But let's be real, a lot of agreements, especially in business, involve way more than two people.
Absolutely. It's very common to have multiple parties in a contract. And this is where it gets interesting, because you can't just assume everyone has the same responsibilities or the same rights.
Right, it's not a one-size-fits-all situation.
Exactly. You have to really examine the specific provisions of the contract to understand each party's liability.
Meaning what they owe.
Exactly.
Yeah.
And their entitlement.
What they're due.
Precisely.
So a single contract can actually be like this whole network of obligations and rights connecting different parties.
That's a great way to put it. It's a network. A contract usually creates multiple obligations, and for each of these obligations, you'll have at least one debtor, the one who has to perform the obligation, and one creditor, the one entitled to that performance.
So in a simple sales contract, the buyer is the debtor when it comes to paying the price, but they're also the creditor when it comes to receiving the goods.
Precisely. And the seller is the opposite.
Right, the seller's the creditor for the payment, but the debtor for delivering the goods.
Exactly. Now, things get even more interesting when you have more than one party on either side of an obligation.
That's when you get co-debtors and co-creditors.
Yes, you got it. For instance, if several people jointly take out a loan, they are co-debtors to the lender.
Who's the sole creditor in that case?
That's right. Or let's say a group of investors pool their money to buy property.
They would be co-creditors to the seller.
Exactly. Now, when you have this multiplicity of parties, it raises a crucial question. How do you determine each co-debtor's share of the responsibility, their liability, and each co-creditor's share of the pie, their entitlement?
Right. If 5 people take out a loan together, is everyone equally responsible for paying it back?
That's one of the key issues. Our sources point to a few factors that determine those shares. Firstly, what did the parties themselves intend? What was their agreement?
Okay, so look to the contract itself first.
Yes. Then, the nature of the contract as a whole can give you clues. And a very important aspect is the nature of the performance owed.
What does that mean, nature of the performance?
Well, can the performance be divided easily, like a sum of money?
Or is it something indivisible, like a unique piece of art?
Exactly. That's the concept of divisibility of performance.
And that plays a big role in how liability and entitlement are determined when you have multiple parties.
A significant role. Our materials highlight that divisibility depends on two things. The inherent nature of the performance itself. Can it be physically or logically split? And like we said before, the intention of the parties.
Right, so even something divisible like money might be treated as indivisible if the contract says so.
Precisely. For example, the full amount might be needed to achieve a specific outcome, and paying in installments wouldn't work. Now let's imagine a common scenario. You have several debtors who owe something to a creditor.
Okay.
And let's say the something is money, which is typically divisible.
Okay.
In this case, there's a strong presumption, according to our sources, that the liability is intended to be simple joint liability.
Not joint and several liability.
Correct. We'll get to joint and several in a bit.
Okay, so simple joint liability, what does that actually mean for the people involved?
Well, in simple terms, it means each debtor is only liable for their proportionate share of the performance.
Okay.
And a key point here is that these shares are presumed to be equal unless the contract specifically states otherwise.
So if 5 friends borrow our 5,000 together, they each owe our 1,000.
Precisely. The creditor can only demand R1,000 from each of them. They can't go after one person for the whole amount.
So if one of those friends disappears or just can't pay up,
The creditor can't demand the missing R1,000 from the others.
so they're basically out of luck for that amount.
Essentially, yes. That's the risk the creditor takes with simple joint liability.
And the upside for the debtors is that their liability is limited to their share.
That's right. Though they might face claims from the other debtors if they end up having to pay more than their initial share.
Okay, that makes sense. But you mentioned this is just a presumption. So what if the contract says something different?
Absolutely. The parties can always explicitly agree to joint and several liability instead, either by clearly stating it or by strongly implying it in the contract.
Or they could decide the shares shouldn't be equal.
Exactly. Maybe one debtor agrees to take on a larger portion of the responsibility.
Okay, so you can contract out of that default rule.
That's right. Now, what about the flip side?
Multiple co-creditors instead of co-debtors.
Precisely. Let's say you have multiple co-creditors who are entitled to receive a divisible performance from a single debtor.
Like a debt owed to a group of investors.
Yes. The principle is similar. Unless the contract says otherwise, each co-creditor is only entitled to a proportionate share.
And again, those shares are presumed to be equal.
Exactly. So if one person owes R5,000 to 5 co-creditors, each creditor can generally only claim R1,000.
What if the debtor mistakenly pays one of those creditors more than their share?
Then the other co-creditors generally have a right to claim their fair share from that overpaid creditor. It's all about maintaining that initial equal division.
Okay, so the law tries to keep things balanced. Now, what happens if a creditor decides to release one of the co-debtors from their obligation?
Good question. Releasing one co-debtor in a simple joint liability situation doesn't automatically release the others.
So the others are still on the hook for their individual shares?
That's right. It's as if that one portion of the debt has been taken care of, but the rest remains.
What if one of the debtors tries to be helpful and pays more than their share?
Or maybe they do it by mistake.
Right. Can they get that extra money back from the other debtors?
In simple joint liability, there's no automatic right to recover the excess. However, if there was a prior agreement among the co-debtors to share any overpayment, that agreement would be binding.
Makes sense.
Also, if the other co-debtors have been unjustly enriched by the overpayment, there might be a legal basis for recovery under the principles of enrichment liability.
But it's not an automatic right.
No, it's not.
Okay, so that's simple joint liability. Now, let's dive into joint and several liability, which you mentioned earlier.
Yes, joint and several liability. This one has more significant implications.
It sounds more serious.
It can be. While simple joint liability is the presumed default, parties can agree to joint and several liability,
Either explicitly in the contract,
or implicitly.
and it can also apply automatically in certain situations.
That's right. Our sources mention that it's often implied in specific contractual relationships, and sometimes it's imposed by statute.
So even if you don't agree to it, you might find yourself in a joint and several liability situation.
That's possible, depending on the nature of the contract and the applicable laws. But let's clarify what it actually means.
Yeah, let's break it down.
The defining characteristic of joint and several liability is that each co-debtor is liable for the full amount of the debt,
The whole thing.
the whole thing.
Wow, so if 5 friends borrow our 5,000 under joint and several liability, the lender could demand the entire amount from any one of them.
That's exactly right. It gives the creditor a very strong position. They can choose to claim the full debt from any one of the debtors, or any portion they want, or even go after multiple debtors simultaneously until they recover the full amount.
That's a lot different from simple joint liability.
It is a significant difference.
So what happens if one of those 5 friends actually pays the full R5,000?
If one debtor pays the full amount, the debt is completely discharged.
Done and dusted.
Exactly.
Yeah.
The creditor can't then go after the other debtors for any more money.
Okay, that makes sense. But what if one of the debtors only makes a partial payment?
That's called part performance, and it reduces the debt proportionally.
Okay.
So if one of the friends pays R2000 of the R5000, the remaining debt is reduced to R3000. The creditor can then pursue the remaining amount from any or all of the other debtors.
All right. Now, what about that friend who paid the full R5000? They paid more than their fair share. Can they get that extra money back?
They can. In joint and several liability, a co-debtor who pays the full amount, or even more than their proportionate share, has an automatic right of recourse.
Meaning they can demand reimbursement from the other debtors?
Exactly. They can basically say, hey, I covered the whole thing, now you each owe me your part.
That seems fair.
It is. The law ensures that the burden is ultimately shared as originally intended.
What if they take it a step further and get the creditor to formally transfer their claim against the other debtors?
That's called taking cession of the claim.
Right. Does that change things?
It doesn't give them any additional rights. They can't use the cession to recover more from the other debtors than those debtors' original proportionate shares.
So even with the cession, they can only get back what each debtor was originally responsible for.
That's right. The cession doesn't create a windfall.
Okay. Now, what happens if the original creditor decides to release one of the joint and several debtors from the debt?
If a creditor releases one joint and several debtors, the liability of the remaining co-debtors is reduced proportionally.
So if there were 5 debtors and one gets released, the remaining 4 are only responsible for 80% of the original debt.
Precisely. It ensures the remaining debtors aren't unfairly burdened by the release of one of their co-debtors.
Makes sense. You also mentioned joint and several entitlement. Is that just the same concept applied to the creditor side?
It is. If you have multiple co-creditors who are jointly and severally entitled to a performance, any one of them can claim the full performance from the debtor.
And if the debtor performs fully to just one of those co-creditors, the entire debt is considered fulfilled.
Exactly. And if one co-creditor receives more than their share, the others have a right to claim their portion from that overpaid creditor.
Okay, so it provides flexibility for both sides.
Yes, it does. The debtor even has some choice in who they pay, unless one or more of the creditors has already formally demanded payment.
Interesting. Now, there's one more type of liability you mentioned, collective joint liability and entitlement.
Right, this one is a bit different. In collective joint liability, the co-debtors are bound to perform the obligation together as a group. The creditor can't demand performance from just one of them individually.
They all have to act collectively.
Exactly. And similarly, with collective joint entitlement, no single co-creditor can claim the entire performance or even part of it on their own. They have to act together.
When does this collective approach usually come up?
Our sources indicate it typically arises when you have two things. First, the performance itself is indivisible. It can't be split up.
Okay.
And second, the parties clearly intended for the liability or entitlement to be collective, not joint and several.
Can you give an example?
Sure. Imagine co-owners of a farm selling it. The buyer would expect all the owners to participate in transferring ownership. They can't just demand a portion of the farm from one owner individually.
Right. It wouldn't make sense to sell off bits and pieces of the farm.
Exactly. And similarly, the co-owners have to act together to claim the purchase price from the buyer.
Okay, so that's collective joint liability and entitlement. So far, we've been talking about situations where everyone involved is a direct party to the contract. But what happens when someone outside that initial circle gets involved?
That brings us to contracts and third parties. While the basic rule is privity of contract, meaning only the parties to a contract have rights and obligations under it, our sources recognize that third parties can be involved or affected in various ways.
So how can a third party get involved if they didn't sign the contract?
There are a few key ways. First, they might be acting as an agent for one of the main parties.
We'll get into that in a bit.
Yes. Second, a third party might be involved in actually carrying out the obligations of the contract.
Like if someone pays a debt on behalf of the original debtor.
Precisely. And third, a third party can become a party themselves.
How does that happen?
They could be substituted for one of the original parties, or they could accept benefits that were specifically offered to them in the contract.
Okay, that makes sense. Let's talk about agents then. That seems pretty common, especially in the business world.
Very common. Many contracts are actually concluded not by the individuals or companies themselves, but by people representing them, their agents.
Like salespeople.
Yes, or lawyers acting on behalf of their clients.
And it's essential when you're dealing with companies.
Absolutely. A company, being a juristic person, can only act through human agents.
Right. So let's break down a typical agency situation.
All right. So you have The person being represented, the principal.
Okay.
Then you have the person doing the representing, the agent.
Okay.
And lastly, you have the other party to the contract, the third party.
So the principal authorizes the agent to represent them in negotiating a contract with the third party.
That's right. The agent then goes out and negotiates with the third party on the principal's behalf. If they reach an agreement, the contract is formed between the principal and the third party.
Not between the agent and the third party.
Generally not. The agent is usually just a go-between, a conduit. They facilitate the agreement, but aren't actually a party to it.
So the agent has a contract with the principal, but they're helping create a separate contract between the principal and someone else.
Precisely. And it's important to note that the word agency can be used in a few different ways. It can refer to the contractual relationship between the principal and agent, the act of representation itself, or even the broader legal framework governing these situations.
So we have to be careful what we mean when we say agency.
We do. We shouldn't confuse the act of representation with the underlying contract between the principal and agent.
Good point. So how does this representation work in practice? What gives the agent the power to act on someone else's behalf?
Representation, legally speaking, occurs when one person, the agent, concludes a legally binding act, called a juristic act, on behalf of another person, the principal. For this to be valid, the agent needs to have the authority, the power, to represent the principal. Now, this power can come from different sources. Sometimes the law itself grants this power.
Like in cases where the principal is a company or a minor.
Exactly. But more commonly, especially in contractual situations, the principal directly grants the agent the power to represent them.
And that's usually through some sort of agreement between them.
That's right. This is called conventional representation.
And when that authorization is given in writing, that's what we call a power of attorney.
Precisely. A power of attorney is a written authorization for someone to represent another person.
But it doesn't necessarily mean they're a lawyer, right?
No, not at all. It simply means they have the authority to act on the principal's behalf within the scope defined in that document.
So it could be a lawyer,
Yes,
or a financial advisor,
absolutely.
or even a family member.
Exactly. And a power of attorney can be general, giving broad authority, or special, limiting the agent's authority to a specific matter.
Okay, that makes sense. You also mentioned the contract between the principal and agent, which is often called a contract of mandate.
Yes, a contract of mandate is essentially an agreement where one person, the principal, gives another person, the agent, a task or a set of tasks to perform.
So it outlines what the agent is supposed to do for the principal.
Precisely. So in a typical agency situation, you have this underlying contract of mandate, and you have the power of attorney, which grants the agent the power to represent the principal in dealing with third parties.
Okay, so let's talk about the relationship between the principal and the agent. What are their duties to each other?
Well, the relationship is primarily governed by the common law principles of mandate and whatever specific terms they've agreed to in their contract.
But the agent is in a position of trust, right?
Absolutely. They have a fiduciary duty to act in the best interests of the principal, putting the principal's interest above their own.
Makes sense. Now, what about the relationship between the principal and the third party, the actual parties to the final contract?
When it comes to whether a valid contract was formed, the law focuses on the state of mind of the agent during the negotiations, not the principal's internal thoughts.
So if the agent believed they were reaching a binding agreement, that's enough,
Generally speaking, yes.
even if the principal had some secret reservations.
Exactly. The agent's understanding is what matters. Also, the principal is generally held liable for the actions of their agent based on the principle of vicarious responsibility.
Meaning what?
It means he who acts through another is deemed himself to act.
So the principal is responsible for what the agent does?
Exactly. For example, if the agent makes a misrepresentation during negotiations, the principal can be held liable for that, even if they didn't know about it.
Even if the agent made the misrepresentation innocently?
Yes, even then. Now, all of this assumes the agent was acting within the scope of their authority when they concluded the contract. If that's the case, the principal is bound by the contract, and so is the third party.
But what happens if the agent goes beyond what they were authorized to do? Is the principal still down?
Generally, if the agent exceeds their authority, the principal isn't bound by the agreement.
So the third party is out of luck.
Not necessarily. The principal might still be liable to the third party on the grounds of enrichment if they benefited from the unauthorized agreement.
So if the principal received some value from the deal, they might still be on the hook.
That's right. Now, there are some exceptions where the principal can be bound even if the agent didn't initially have the authority.
Okay, so what are these exceptions?
The first is ratification. Even if the agent acted without authority, the principal can later approve or confirm the contract.
Like a retroactive authorization.
Exactly. For ratification to be valid, the agent must have said they were acting as an agent, and the principal must have existed at the time the contract was made.
Okay, what's the second exception?
The second is estoppel, where the principal is prevented from denying the agent's authority.
Because they created the impression that the agent had the authority.
Precisely. This is called agency by estoppel.
So if the principal's words or actions led the third party to reasonably believe the agent had authority, the principal can't later say the agent didn't.
That's the gist of it.
You also mentioned a case, McCarty v. Vodacom. How does that fit in?
In McCarty v. Vodacom, our constitutional court ruled that a principal can be bound even if the agent didn't have actual authority, as long as the agent had a sensible or apparent authority.
So it's about how things appear to the third party.
Exactly. If the principal creates the impression that the agent has authority, they're bound.
Okay. Now, what about this doctrine of the undisclosed principal? It sounds a bit mysterious.
It's a situation where the agent has the authority to act, but they don't reveal to the third party that they're actually acting as an agent.
So the third party thinks they're dealing directly with the agent.
That's right. In this case, the agent is personally liable on the contract because, as far as the third party knows, they're the one making the deal.
But the principal can still step in later.
They can. The doctrine allows the undisclosed principal to emerge later and demand performance from the third party.
But there are some conditions, right?
Yes. The third party can't have already fulfilled their obligations to the agent, and the principal's emergence can't cause any unfair prejudice to the third party.
That seems a bit tricky for the third party. They might have negotiated a specific deal based on who they thought they were dealing with.
That's a valid concern, and this doctrine has been criticized for potentially contradicting fundamental principles of contract law.
But it's still good law.
It is.
Mm.
In a case called Cullinan v. Nordkap Lands, Artepelker Moore Quickers, Cooperazi, BPK, the court acknowledged these complexities, but ultimately upheld the doctrine.
So it's been around for a while and is still in force.
That's right.
What happens if the third party eventually finds out about the undisclosed principal?
They generally get a choice. They can claim performance from either the agent or the principal, but once they choose, they can't go back and try to sue the other one.
So they have to pick a side.
That's right. Now, there's also the unidentified principal, which is slightly different.
Okay, what's the difference?
In this case, the agent tells the third party that they're acting for a principal, but they don't reveal the principal's identity.
So the third party knows they're not dealing directly with the decision maker, but they don't know who that decision maker is.
Exactly.
Yeah.
In this scenario, the contract is formed between the third party and the unidentified principal, not the agent.
All right. Now, what if the principal doesn't even exist yet at the time the contract is made?
Under common law, you can't represent a non-existent principal. Any contract made on their behalf is void from the start.
So the contract is basically a dud.
That's right. But there's an exception for companies.
Oh, right, because companies are formed through a legal process.
Exactly. Company legislation allows for contracts to be made on behalf of a company that hasn't been fully incorporated yet, under certain conditions.
So you can have a contract waiting in the wings for the company to be born.
That's a good way to put it. But the contract only becomes binding on the company once it actually exists and formally adopts or ratifies the pre-incorporation contract.
Okay, so there are special rules for companies' information. Now, what about the relationship between the agent and the third party?
Generally, if the agent acts within their authority, they don't have any personal liability to the third party on the contract itself.
If they were just the messenger.
Exactly. But if they act without authority or exceed their authority, they can face liability.
They could be liable for breach of warranty of authority if they basically promised they had the authority when they didn't.
That's right. And they could also be liable for delict if they misrepresented their authority, either intentionally or negligently.
So they have a responsibility to be truthful about their power to act on the principal's behalf.
Absolutely.
Okay, now let's move on to stipulation to the benefit of a third party.
This is another way someone who didn't sign the contract can still get something out of it.
Like a gift.
Not exactly. It's more about a deliberate intention by the contracting parties to benefit a third party.
Okay, can you give some examples?
Common examples include pension agreements, where future beneficiaries are named, or life insurance policies, where the payout goes to a designated beneficiary upon the insured person's death.
Okay.
Even inter vivos trusts, where someone sets up a legal arrangement to hold assets for the benefit of others during their lifetime, are an example.
So all these situations involve a third party who didn't sign the contract but is supposed to receive a benefit.
Precisely.
But how do they get the legal right to that benefit if they weren't part of the contract? Doesn't that go against privity of contract?
That's a key question. While traditionally only contracting parties had rights, South African courts have been willing to enforce contracts made for the benefit of third parties. They've developed rules to allow those third parties to claim their intended benefits.
So it's a recognized exception to the strict privity rule.
Exactly.
So the beneficiary named in a life insurance policy can go directly to the insurance company and claim the money.
That's right. They're an intended beneficiary.
What about situations where someone benefits but wasn't specifically intended to?
Those are called incidental beneficiaries. They might benefit indirectly, but they generally have limited or no rights to enforce the contract.
Can you give an example?
Imagine two companies sign a contract that leads to increased business for local shops in their town.
The shop owners benefit from the increased activity, but they weren't specifically intended to benefit from the contract between the companies.
Exactly. They're incidental beneficiaries. Or imagine a company agrees to provide IT services directly to a subsidiary of another company. The subsidiary would be the intended beneficiary, while the subsidiary's employees might benefit indirectly but wouldn't be able to enforce the contract themselves.
So it really boils down to the intention of the original parties. Did they want that third party to have enforceable rights?
Precisely. And if you're drafting a contract that involves third-party beneficiaries, it's crucial to be clear about their status and rights. Specify who the intended beneficiaries are and what they're entitled to.
To avoid potential disputes down the line?
Exactly.
Well, this has been a really comprehensive deep dive into the parties involved in a contract.
We've covered a lot of ground.
We started with the fundamental requirement of at least two parties, then explored different types of liability and entitlement when multiple parties are involved.
Joint, and several, and collective.
And we looked at the important roles third parties can play through agency and as intended beneficiaries.
It's definitely given us a clearer understanding of the complexities that can arise in contractual relationships.
Absolutely. And it leads to a final thought for our listeners. As agreements become more complex, with new types of multi-party relationships and the rise of digital interactions, how will these principles need to adapt?
It's a great question. The legal landscape is always evolving.
And for those who want to explore further, diving into case law like Makati v. Vodacom can provide deeper insights into agency, and researching third-party beneficiary law can be really interesting.
Absolutely. Understanding these core principles is key to navigating the world of contracts.
Thanks for joining us on this deep dive.
It's been a pleasure.
See you next time.
See you.